Hi, very good morning. This is a Supreme Court judgment under the Arbitration and Conciliation Act. The citation is Danny Wooltex Corporation versus Shale Properties Private Limited. Facts of the case: DWC is a partnership firm. It owned a certain place in Mumbai. Shale was engaged in real estate development. DWC entered into an agreement for development of a portion of a land by Shale. Then there was another company called Marico. Marico was engaged in the business of consumer goods. A MOU was executed between DWC and Marico, by which DWC agreed to sell a portion of the land to Marico. So, first there was an agreement between DWC and Shale to develop a portion of the land. Second, there was an MOU between DWC and Marico to for the purpose of sale of a portion of the land. So, Marico advertised public notice they gave that this land is going to be sold to us. If anybody has got any objection, please inform us. Then Shale, who was the property developer, he objected to that. He said, no, we have objection in this. Then Shale instituted a suit against the sale of land to Marico. Marico also filed a suit in the court. Both of them, or all the three of them, agreed that the matter should be resolved by an arbitrator, by appointment of an arbitrator. So, what happened was the arbitrator, when the arbitrator was appointed, Shale filed a separate claim, statement of claim. Then Marico filed a separate statement of claim. Both of them filed a separate statement of claim. Both the matters were taken up separately. Both proceedings were taken up separately by the arbitrator, common arbitrator. For some reason, Marico's application, that statement of claim, was considered, and then matters were heard. Award was given. The case filed by the statement of claim filed by Shale, it was not taken up for some reason. It was pending for more than 8 years by the arbitrator. It's COVID happened, everything happened. Then the DWC went and filed an application before the arbitrator to terminate the proceedings of Shale because it was pending for a long time. It was not pursued. So please dismiss the claim of Shale. That is the application made by the DWC. Arbitrator also agreed and terminated the statement of claim filed by the Shale. This was challenged by the Shale before the Bombay High Court. High Court said to the arbitrator, you continue with the proceedings. No, you cannot terminate the proceedings like this. You continue with the proceedings. Then, in the meantime, what happened? Arbitrator resigned. He said, no, I don't want to continue as arbitrator. He has resigned. The order of the Bombay High Court was challenged before the Supreme Court by DWC. Now, the interesting thing is, when the arbitrator can terminate the proceedings, that is the question. Or the question is, when a person has said to be abandoned his claim, that is the question before the Honorable Supreme Court. Supreme Court examined the provisions. A slight touch upon the examination of the provisions is also important for this case. Supreme Court says, after analyzing the provisions, Chapter 5 contains the provision regarding conduct of arbitral proceedings. If parties do not agree on timelines for filing the statement of claim and defense, the arbitrator or arbitrary tribunal, we will say hereafter tribunal, has power to determine the timelines for filing the pleadings. The filing of the pleadings should be completed within 6 months from the date, the learned arbitrator receives notice in writing of their appointment. This is as per section 23(4). Next stage is hearing stage. First appointment is over. When the statement of claim has to be filed, everything has been said. 6 months time will be given. Now hearing stage. Hearing stage, parties should be given sufficient notice of any hearing or meeting by the tribunal for inspection of documents. Now this is very, very important. Section 25A states that only on the failure of the claimant to communicate the statement of claim, the tribunal shall terminate the proceedings. I repeat, 25A says only on the failure of the claimants to communicate the statement of claim, AT shall terminate the proceedings. Section 25B says if the respondent fails to communicate his statement, tribunal shall continue the proceedings. 25C says if party fails to appear at an oral hearing or produce documents, tribunal may continue the proceedings and make the award on the basis of the evidence on record. The power to terminate from this, from the analysis of provisions, is that only on the default of the claimant to file a statement of claim, then the proceedings can be terminated. Now, Supreme Court entered into when the arbitrator's mandate terminates. In the case, the arbitrator was under an impression that unless the parties move the tribunal with a request to fix a meeting, the tribunal was under no obligation to fix the meeting. The arbitrator was happily, you write to me, I will fix the date. That kind of this thing. Supreme Court said, arbitrator does not do pro bono work. For him, it is a professional assignment. A duty is cast on the arbitrator to adjudicate the dispute and make an award. An arbitrator cannot say that he will fix a meeting unless the parties request for the same. If you don't ask for a meeting, I will not fix the date. That attitude is not accepted. It is the duty of the arbitrator to do so. He has to fix a meeting. If the claimant fails to file a statement of claim, arbitrator can terminate. That we have seen. That is the only reason for which proceedings can be terminated. If the respondent fails to file the state defense, the arbitrator is bound to proceed with the proceedings. Suppose let us assume a case where the claimant also fails to appear for the oral hearing after filing the statement of claim. Then also arbitrator is expected to continue the proceedings and make an award. Supreme Court examined section 14 and 15 and said, arbitrator can withdraw from the proceedings because of non-cooperation of the parties. In that case, his mandate will be terminated. Section 32 of Arbitration Act says the termination of the proceedings can happen only in the following contingencies. Not briefly I am giving this because this is important for the case. One is on making a final award. Second is claimant withdrawing his claim. Third is parties agreeing on termination of arbitral proceedings. Fourth is the very, very important. This is the important for this case. When the arbitrator finds that the continuation of proceedings has become unnecessary or impossible for any reason. Within quotes, unnecessary or impossible for any reason. Under the last condition, the mere existence of a reason is not enough to terminate the proceeding. The reason must be such that continuation of the proceedings has become unnecessary or impossible. Claimant's failure to appear after filing the claim cannot be a ground to say that proceedings have become unnecessary or impossible. Supreme Court says that abandonment of claim by the claimant may be a ground for saying that proceedings have become unnecessary. But the abandonment must be established. It may be either express or implied. It cannot be readily inferred. One can say that there is an implied abandonment when admitted or proved facts are so clinching and convincing that the only inference which can be drawn is of the abandonment. Mere absence in the proceedings or failure to participate does not per se amount to abandonment. That is, you file a claim, but you do not appear in the hearings. That does not mean you have abandoned your claim. Only if the established conduct of a claimant is such that it leads to only one conclusion, that the claimant has given up his claim, then only an inference of abandonment can be drawn. Merely because a claimant, after filing a statement of claim, does not move the arbitrator to fix a date of hearing, cannot be said that the claimant has abandoned his claim. That is what this case is. It is the arbitrator's duty to fix the date of hearing that we have seen. The Supreme Court held in this case there was no express abandonment of claim by the Shale. Even if it is to be implied, there must be convincing circumstance on record which lead to the inevitable inference about the abandonment. There was no express or implied abandonment in this case. The inference of abandonment was taken by the arbitrator on the ground that Shale did not challenge the Maricos award, because already we have seen only Maricos proceedings continued and an award was passed, not the Shale's case, and took no steps to convene the meeting, the arbitrator. The failure to challenge the award will not amount to abandonment of claim. The finding is clearly illegal. So Supreme Court upheld the order of the High Court. Then Supreme Court directed the parties to appoint a new arbitrator and continue the proceedings because the arbitrator has already withdrawn, the previous arbitrator. This is the case. So I thought this is a wonderful case which I must share. Thank you very much. Have a great day.